good morning. Yes, this is an interesting quirk in US customs law that more and more companies have been flagging as a means of mitigating the largest impact of tariffs. It's a decades-old provision known as the first sale rule, and this essentially allows a company to claim its import duty based on the initial price of a good in a series of transactions. So let's say, for instance, a Chinese manufacturer produces a T-shirt for $5. A Hong Kong vendor then sells that on for $10 to a US retailer, that US retailer then selling it on to the consumer. Now, typically, that US retailer would claim its duty based on that larger $10 cost. But under the first sale rule, they can claim against the initial $5, essentially cutting out the costs associated with the middleman's profits. Now, this rule, like I say, has been around since the late 1980s, but it has gained renewed attention under President Trump's tariff agenda. And this is seen a spike in use both in his first term when he introduced those 25% levies against China, and certainly now renewed attention again as he's imposed these new tariffs against countries more broadly. Now, there are a few criteria, of course, that a company must fulfill in order to be eligible to use this rule. There must be at least 2 sales, so this from the initial manufacturer and then an intermediary. It must be conducted at arm's length, so these parties cannot be related, and the item must ultimately be destined for the US. Now, of course, this adds a little bit of complexity to the reporting process for these companies, and it can be problematic in that potentially a vendor may not want to reveal its margins, so it may not want to provide that information to the ultimate importer. But certainly legal experts and businesses I've spoken to have said it might just be worth that added hassle because it will allow these companies to continue that relationship and remain competitive where other companies might be using this too. And
could seriously mitigate the impact of the tariffs if they're only having to absorb a small, a smaller rate. If the cost of the goods they're talking about is considered much lower. What companies are utilizing this rule?
Yeah, it's a great question. They really do span a variety of sectors, and those particularly with larger margins. So we're talking about luxury goods, electronics, retail, pharmaceuticals. So Moncler, in its first quarter earnings, flagged the use of this rule. So this Italian luxury company. We've also had Cora Biosciences. This is a Swiss biotech, and also a US barbecue maker, Traeger. So it really does span a broad range.
You talk about them potentially not wanting to reveal their margins to their end, the end importer. But what about to customers? When you actually look at the margin that these luxury companies are making.
What we're seeing on the screen here,
it's huge.
Talk about those margins. But I assume, Karen, you can almost not afford to not use the rule. You have to. If everyone's doing it, you're going to have to use it too. Otherwise, you're at a competitive disadvantage.
Exactly.
Right?
This is what the legal advisors have said. A lot of these competitors will be doing it. So it's in a company's interest to go around these added hurdles. Even if it is a little bit more reporting, they will be willing to do it. The White House has not responded to a request for comment from CNBC on the use of this rule because it could certainly have an impact on Trump's tariff agenda.
We're talking margins to the tune of 80% in some of these cases. So you certainly, if you're a company, it is probably worth your while.
Yeah. Right. Great reporting, as always. Thank you so much. For more, check out Karen's article on CNBC.com.